Thanks very much to all of you on the call for coming along after hours to learn a little bit more about our latest discussion paper in the Heritable Securities Project. I'm sure after a long day, a bit of dense discussion about sub-securities might not be exactly what you're looking forward to, but I'll try to keep it as manageable as possible. I'll start just by giving you a quick overview of where we're at in this project on heritable securities, just in case you've not been religiously following developments to date. So the Scottish Law Commission is currently engaged in this general overview of the law of heritable securities. So it's a long-term project. It started in 2018 and it's due to finish in 2025. What we're doing is basically just a comprehensive overview of the entire law of heritable securities in Scotland. A lot of that focuses on Part 2 of the Conveyancing and Feudal Reforms Scotland Act 1970, which is the key bit of legislation for standard securities, but we are looking at everything else as well. We have been tackling the subject matter of the project in 3 discussion papers. So the first discussion paper came out in 2019, the middle of 2019. That looked at pre-default issues, so creation of standard securities and assignation of standard securities largely was what that paper dealt with. In the second discussion paper, which came out in December of 2021, we looked at default and post-default issues, so how you exercise a standard security, what remedies it makes available, and how you go about using those remedies in the event of default. And now in this third and final discussion paper in the project, we're looking at 2 specific complex issues which emerged from consultation in the earlier part of the project as being areas which needed specific attention. So one of them is non-monetary securities and the other is sub-securities. And obviously I will be talking a lot more about both of those things just in a minute. The idea is that all the material in all 3 of these discussion papers and the analysis of the consultation responses will all be drawn together into one single final recommendations report from us to government, accompanied by a draft bill, a draft piece of legislation, which is due in 2025. The hope or the intention is that this piece of draft legislation should replace Part 2 of the Conveyancing and Feudal Reforms Scotland Act and other relevant bits of legislation, so that we will just have essentially a new code of standard securities for Scotland. That's the intention. So that should be out in 2025. Once that leaves our hands, then it's up to government to decide what they want to do with it, if they want to implement it or if they just want to stick it on a dusty shelf, which hopefully is not the case. So I wouldn't expect there to be any new legislation. You know, it'll be there's a Scottish Parliament election in 2026 as well. So realistically, there's not going to be any new legislation until 2027, 2028, something like that. So it is a long-term project, but we are working our way through it. And now I think we're closer to the end than the start. So from my perspective, then that's quite a positive sign. So that's the project as a whole. The focus in the presentation today is obviously going to be on this new 3rd discussion paper. I'll just give you a quick overview of what is in that paper, and then I'll get into a bit more detail on each of the sections that make up discussion paper 3. So first of all, the discussion paper looks at how to deal with non-monetary securities in future. So the question here is basically, should it still be possible in future standard securities legislation to secure obligations with no financial component? So should it still be possible in future legislation to secure entirely non-monetary obligations? I'll talk about that a bit more in a minute. The second big chunk of the paper looks at a suggested new scheme for protecting obligations to transfer land. This is really the chunkiest bit of the paper. When we looked in our first discussion paper about securing non-monetary obligations, then what we found was obviously that the biggest chunk of non-monetary obligations that are secured are obligations generally undertaken by landowners in an option agreement or something like that to transfer ownership of land. Subject to the fulfillment of certain conditions. Those types of obligations people are keen to be able to protect, and there's no real mechanism for doing that at present apart from taking a standard security. But taking a standard security in respect of an obligation like that is a bit of an unwieldy solution to something that really should be perhaps a bit simpler. So what we are proposing in this discussion paper is an alternative mechanism for protecting those type of obligations, which is based on the advance notice system, which is in use on the land register at the moment. So I'll outline for you this proposed new scheme for protecting obligations to transfer land. I will also outline for you in briefer terms some other potential mechanisms that we looked at to be able to provide this protection to obligations to transfer land, but we ended up discounting because it seemed to us that this advance notice scheme-based solution was the preferable one for various reasons, what I'll get into. But I'll outline for you the other things that we looked at. Should emphasise that we are obviously very much still in the consultation phase in respect of these ideas, so nothing is set in stone as yet. Everything's still on the table. These other ideas can still be explored if it seems to consultees that one of these other options is preferable to the one that we've kind of promoted in the discussion paper so far. So that's the non-monetary security stuff. The other bit of the paper is about sub-securities. So by sub-securities in this context, what I'm talking about is where a standard security is taken over an existing standard security. So this kind of secondary standard security or a piggyback security kind of situation. That's the sub-securities we're interested in here. So the first chapter looking at sub-securities is really focused on this question of whether it should continue to be competent to take a standard security over a standard security in any future legislation. So just the spoilers there, we don't think that it should be, probably. So then the final chapter of the discussion paper is focused on whether we need a replacement for taking a standard security over a standard security, because if so, then an assignation in security of a standard security might seem the obvious way to do that. And I'll explain a bit more about that when we get to it. Now, I'm quite conscious here that these are two areas which are unlikely to be of equal interest to everybody on the call. So if you're more of a comp-prop real estate type person, then you're probably more interested in the non-monetary security stuff and the protecting options stuff. And if you're in the banking side of things, then you're probably more interested in sub-securities. So I'm sorry if this is a bit kind of, you're not equally as interested in everything in the webinar, but we'll try to keep it pretty brief, and hopefully you can still find something in it to find interesting. On that note, I should also say, we really hope that people will respond to the discussion paper, put in some consultation responses to the discussion paper. That's kind of part of the reason for doing the webinars. Please don't feel that you need to put in a response that answers every single question in the discussion paper, particularly if you think, I don't have any opinions on sub-securities. I've never come across this in practice. I'm not interested. It's absolutely fine to just not answer those questions. It's not like an exam where you're kind of expected to put in a full answer to everything. If you want to put in a response that only looks at one or two issues in the paper, that will absolutely be welcomed. There is no requirement to answer every single question in the paper. There's also no requirement to write essay type answers to all of the consultation questions. Simple yes or no answers can also really help us to get a feel for what the view is amongst consultees and particularly amongst practitioners. So please don't feel that this needs to be a mammoth undertaking. We just want to hear whether you think what we are suggesting works, or if you can spot problems in what we're suggesting, then that's great. This is not to say don't submit a full response, by the way. We also love to get full responses, but just don't feel that you're under an obligation to do that if it's really not of interest to you to answer some of the questions. Okay, so that's the gist of it. Let me get into the detail of it. So the first big issue that we tackle in the paper is this question of security in respect of non-monetary obligations. So we did discuss this in the first discussion paper in the project. Scotland is really quite an outlier in the way that our standard securities legislation allows for security to be taken just in respect of any kind of obligation ad factum praestandum. If you look at comparator jurisdictions, then what is much more normal in their standard security equivalents, so their rights and security in respect of heritage, might be, mortgages or hypothecs or whatever it is in their jurisdiction, often it will be the case that those rights and security can only be taken in respect of a monetary obligation, or else a non-monetary obligation, but only if it's backed up by some sort of substitutionary financial obligation. So you can have a security for a non-monetary obligation, but only so long as there's an explicit claim for damages if that obligation is not performed or if the obligation is breached, for example. So the fact that Scotland doesn't require any of that, that we just have this blanket, you can take a security in respect of any obligation ad factum praestandum, is quite unusual. Now, in the discussion paper, we look a bit at the history of our law of heritable securities to try to understand how we got to this place. And we also look at the types of non-monetary obligations that tend to be secured by a standard security in practice. So in the discussion paper, we've got a list of examples that we're aware of. We're always very keen to hear more. So if you're looking at that list and thinking, oh, well, I know another situation where a non-monetary standard security will be taken, we'd very much like to hear about that. But when we look at the list of examples that we've been able to uncover so far, then what really comes out of it is it's not so important necessarily that an obligation is expressed in a non-monetary way. What is important is whether a financial remedy is going to meet the needs of the creditor of that obligation. So what I mean by that is sometimes you have obligations that are expressed in non-monetary terms, but where the creditor would clearly be happy with money if the obligation is not voluntarily performed by the debtor. So if it's an obligation to make overage payments or an obligation to buy stocks and shares, those are not strictly speaking financial obligations because they are not obligations to pay money. But nevertheless, so long as the creditor can get money, then they will be able to make sure that the obligation is satisfied or they can get what they need out of that obligation being agreed in the first place. So those types of non-monetary obligation are kind of not so difficult to deal with within the scheme of our existing standard securities legislation. The more difficult cases are the non-monetary obligations where money is just not going to cut it. And that tends to be the types of obligations that involve transfer of land or grant of subordinate real rights. So if you're, assembling a land package and what you really need is ownership of this part of the jigsaw, then the fact that you can get damages for breach of your option agreement is not going to satisfy you as a creditor. The standard security isn't really doing what you would ideally like it to do there. So that's really the fact that obligations are monetary or non-monetary maybe isn't as important as the question of whether a financial remedy will meet the needs of the creditor or not. Now, when we looked at this in the first discussion paper in the project, we consulted on what future legislation should do with non-monetary obligations, but the responses that we received to that and the discussions that we've had with people subsequently have been dominated by this question of the transfer of land type obligations or these land related obligations. So the responses we got were all very much, look, you need to still be able to take a security in respect of a non-monetary obligation, or else how are we going to protect our option agreements? So we thought it would be worth reconsulting now that we are suggesting a different solution to that option problem to see where that leaves us with respect to the other types of non-monetary obligation. And the question we're putting forward, very similar to the one we asked in the first discussion paper, is in future legislation, should it only be possible to grant security for monetary obligations? Like, should that be all that's allowed? You can only grant security in respect of a monetary obligation, albeit that could be a damages claim in respect of a primary non-monetary obligation, but your obligation would need to have some financial element to it. Should that be the only type of obligation in respect of which a security can be granted? Or should we continue to allow security in respect of ad factum price standing obligations just generally as at present, but legislation will clarify that only a financial remedy will be available to the security holder under the security. So even though the obligation is expressed in non-monetary terms, it will be clear in legislation that all that can be gained from the security in that context is some sort of damages payment or some sort of financial payment. So that's the question that we ask. Part of me is quite attracted to the sort of simplicity of the just saying you can only have a security in respect of a financial obligation. But I know from speaking to our advisory group that some people are attracted by the flexibility of saying, well, you can still secure any non-monetary obligations with the clarity coming in the legislation. So we'd be interested to hear people's views on that, just to tighten up the law a little bit in future legislation. That's the non-monetary obligation stuff. The next big chunk of the paper is on an alternative mechanism to protect obligations to transfer land. Okay, so this is the chunkiest bit of the discussion paper. The paper as in itself is not that long compared to the other two discussion papers in the project. I think it's about 80 pages, where the others have been more like 180 pages. So it is shorter and it has fewer questions. I think there's 17 consultation questions altogether, as opposed to like 80 or whatever was in the second discussion paper. Most of the consultations are about this proposed new scheme to protect obligations to transfer land. So this is kind of where all the detail is. What we are suggesting here is, well, first of all, to explain, people on the call will realise the problem that we're looking to solve here is the problem of how to hold a landowner to obligations that they undertake in an option agreement or a similar type of agreement. So these might normally be an obligation to transfer land on the fulfilment of certain conditions, such as the grant of planning permission. It might also be an obligation to grant a lease, or there may be other types of real rights involved. But what we're interested in is obligations to grant or transfer real rights, registrable real rights, I should say. This is a register-based system. So how can we protect these things? So at the moment, if a landowner has entered into an option agreement with, say, a developer, which says, they grant them an option to purchase the land if certain conditions are fulfilled, and then despite having entered into that option agreement, the landowner just decides, in breach of the option agreement, to sell the land to a third party, there might not be that much that the option holder can do about it. So yes, the option holder would be able to claim damages because there's been a breach of the contract, but damages might not really be what you're looking for in that situation, might not really suffice to meet the needs of the security holder in that situation. What normally, or the only real way that you can kind of protect yourself at the moment, if you're the option holder in that situation, is to take a standard security in respect of the option. The standard security will advertise on the face of the register the fact that the option exists, and that may allow you to reduce any competing transaction on the basis of the offside goals rule. But obviously, nobody in their right mind would be trying to rely on the offside goals rule as their favoured approach to resolving any kind of problem. Nobody loves the offside goals rule. It's nobody's favourite piece of legal doctrine in Scotland. So a solution that relies on that is probably not a very good solution. So we're looking for some way to protect option holders or to hold landowners to the obligations they undertake in an option agreement, which is better than using a standard security for it. And what we have come up with is a system that is based on the current advance notice scheme. So if you, I'm sure everybody's probably pretty familiar with advance notices. The way advance notices work are to protect the buyer of land against the gap risk that emerges in the period between, at the settlement point in a transaction, there's a period between delivery of the disposition and registration of the disposition, or even just immediately prior to delivery of the disposition and registration of the disposition. During that period, what you don't want is for the seller to transfer the land to somebody else or to become insolvent and be sequestrated, because that's obviously going to have an adverse impact on the title that you acquire, if you can acquire any title at all. So the way that we solve that is by the advance notice system. What happens is that the seller of the land, the current owner, enters an advance notice on the register saying that they intend to grant a specific deed, let's say it's a disposition, to the buyer. That goes onto the register, and then so long as the buyer registers the deed that is identified in the advance notice during the protected period of 35 days, that protected deed, the one that's identified in the advance notice, that will take priority over any competing deed that is registered in the land register during the protected period. That's the gist of it. What we are proposing is something similar for the types of conditional intention to grant a deed that a landowner undertakes when they enter into an option agreement or a similar type of undertaking. So it will be like the advance notice system, but in respect of conditional intention to grant a deed and in place for a much longer period than 35 days to take into account the length of time for which an option agreement would usually be in place while parties are determining whether the option is to be exercised or not. So here's the way it would operate. So first of all, I should say, by the way, we're not married to this conditional advance notice. So if you don't like the name, we consult on whether another name would be better. But conditional advance notice is what we've got for the time being. Okay, so the way it would work is this. Parties have entered into an option agreement. The landowner would enter onto the register a conditional advance notice. The conditional advance notice will say, I, Joe Bloggs, right, the owner of the land, have a conditional intention to grant a specified deed. So it will say a disposition or a lease or whatever it is. I, Joe Bloggs, have a conditional intention to grant a disposition to Development Company A in implement of obligations undertaken in a contract dated the 17th of August 2023. Okay, that's what the notice will say. So quite brief, just the way current advance notices are. In the discussion paper, we consult on the precise detail of what should be in the conditional advance notice, what the content of it should be. But the idea is it's something quite brief. So it just identifies the parties, identifies the conditional obligation and the deed that's intended to be granted. The owner of the land will then enter that, or the intended grantor of the deed in question will enter that conditional advance notice onto the register against title to the property in question, you know, the property in respect of which the deed is going to be granted. And that conditional advance notice will provide protection against voluntary competing deeds granted during the protected period. So when I say it will provide protection, what I mean is that if a voluntary deed is registered against the same title during the protected period, and that voluntary deed would adversely affect performance of the protected obligation. So you've got a voluntary competed deed granted during the protected period, and that deed is going to adversely affect performance of the protected obligation. You know, it's going to adversely affect the landowner's ability to deliver a disposition, or, you know, it will adversely affect performance of the protected obligation, then the party to whom the conditional obligation is owed, the deed is ineffective against that party. So the competing deed is ineffective against the party protected by the conditional advance notice. The competing deed is ineffective against the option holder. Usually that's the person who you'd be talking about. So when I say it's ineffective, what that means is that the option holder, or the person who's protected by the conditional advance notice, they would be able to reduce, set aside a competing deed if that competing deed was going to prevent the conditional obligation from being performed. Or alternatively, if the protected party, the party protected by the notice, if they have their own disposition, they could, or whatever the deed is, if they have their own disposition, they can register the disposition in the register, and it will automatically take priority over any competing deed in the same way as happens with advance notices at present. So it's basically a protection against the landowner taking actions which interfere with their ability to perform the conditional obligation. It gives the option holder a way of unstitching any of those types of transactions. That's the key protection that we envisage the conditional advance notice will provide, is this protection against voluntary competing deeds, you know, against intentional breach of the option, or voluntarily granted competing deeds. But we also look at whether there should be protection against involuntary competing deeds that are registered during the protected period. So as I mentioned, in the existing advance notice scheme, once an advance notice is on the register, then the person identified in the advance notice as the recipient of the protected deed, they'll be protected against, if it's a human being who's the seller, against their insolvency or against inhibition. Like, those involuntary events are also protected against in the existing advance notice scheme, which is fine, but it's a bit more complicated to work out in policy terms whether that should also be the case for the conditional advance notice, just because the protected period for the conditional advance notice is going to be so much longer. So if you think you've got an option agreement that's maybe going to be in place for kind of 3 years, but within the first 6, and the conditional advance notice is entered onto the register against the property in question, if the landowner then becomes insolvent within the first 6 months, the option holder isn't yet going to know probably whether they want to exercise the option. And if the conditional advance notice protects against involuntary events, then that bit of property is kind of in limbo while all of those investigations continue to see whether the option holder wants to exercise the option or not. Now, arguably, keeping a big chunk of property like that in limbo is not very fair on the landowner. It's arguably not very fair on other creditors in the insolvency. It's maybe also not that likely to be what the option holder wants in that situation, because if the person you've contracted with has gone insolvent, there are probably other problems there. So maybe the case for including that protection within a conditional advance notice scheme is not as clearly made out. So we consult on that question. I'm not too sure what we should do there. The advance notice scheme as it currently stands doesn't provide any protection against corporate insolvency anyway, so really only talking here about dealings with human beings who are landowners rather than business entities that are landowners, but we asked the question about that. So that's the gist of how it should work. As I've mentioned repeatedly, the protected period will need to be much longer, obviously, for a conditional advance notice than for the current advance notices. What we're really looking for is a period that would cover the duration for which most option agreements tend to be in place. And we're just looking for input on what that is. So maybe that's 2 years, maybe it's 3 years, maybe it's 5 years. We just asked quite a sort of open question about that, but it will need to be a longer period. We also think it probably would be appropriate for the protected period of a conditional advance notice to be able to be extended at the end of the initial protected period. So that's not possible with current advance notices. If you get to the end of the protected period, you can register a new one, but you can't actually extend the protected period. But we think for conditional advance notices, it should be possible to do that if the parties want to do it. So we consult on that question. We also think the conditional advance notice should be assignable, because obviously the claim under an option will sometimes be assigned. And if you're the assignee of the claim, then you will no doubt also want the protection of the conditional advance notice. So that should be possible. And we also look at how conditional advance notices can be removed from the register at the end of their useful lifetime. So as with existing advance notices, we just suggest they should be deleted from the register at the end of the protected period, assuming the protected period hasn't been extended. but also we think there should be a process in place for discharging a conditional advance notice in much the same way as you would discharge a standard security in case parties want to get rid of it partway through the protected period. So we consult on that and on circumstances in which, you know, you would expect parties to consent to the discharge of the notice, but maybe there are circumstances in which the court should be able to substitute consent for the parties, and we consult on that sort of question as well in the DP. So that's kind of what we're proposing. We thought that was the most likely scheme to provide the protection that is being looked for here in terms of option agreements and so forth. But we did have some other questions about it. One question we had is about the extent to which, or the interaction of any conditional advance notice scheme with purchase options held by tenants in leases. So a tenant who has a purchase option in a lease is probably in quite a different position in most respects from the holder of a kind of standalone commercial option, not least because they are in occupation day to day of the property in a way that an option holder won't be, so they can kind of control what's happening to it. But also it might not be that unexpected if you are a tenant for your landlord to change. You know, that's in certain types of commercial lease, then that might be not uncommon for that to happen. So a solution that's based on preventing transfers might not make as much sense in that sort of context. We also have a policy problem here because it's quite clear in the law of leases that tenant purchase options are not internaturalia of a lease. So there's a clear line of case law that says a tenant cannot enforce a purchase option against a singular successor of the landlord with whom they agreed that purchase option. So if we say that conditional advance notices can apply here, we're kind of undercutting that policy, which maybe is a bit strange to do in a project about heritable securities, particularly bearing in mind that at the Law Commission we are also currently running a project on leases, which does intend to look at internaturalia lease terms. So there might be a case for saying we should put a pin in this for the moment and leave this to be dealt with as a matter of the leases project. So we just are looking for views on how you think conditional advance notices might interact with tenant purchase options. We do also look in the DP at other mechanisms that might potentially be used to protect obligations to transfer land if people are not attracted by this conditional advance notice scheme that we've set out. So we looked at whether it might be possible to have a bespoke set of remedies within the law of standard securities to cover securities in respect of these kind of obligations to transfer land. Once we got into that, it's a bit like you would essentially need to rewrite all of the law of standard securities to have a sort of a different type of standard security for an obligation to transfer land than the standard security that you would have for normal financial obligations. And it just seemed like a lot of work to do something that could be more simply achieved by an advance notice type scheme, which is why we just set that to one side. The second alternative option we looked at was introducing a sort of a form of personal real burden that would allow the holder to enforce the obligation undertaken in the option against whoever happened to own the land at the time. So the personal real burdens are these burdens you can have where the benefited proprietor does not have to own adjacent land. Usually at the moment they are held by kind of public bodies to protect matters of public interest, you know, so you've got kind of conservation real burdens and climate change real burdens and these sorts of things. They're not generally used in kind of private or commercial transactions. So that's a bit of a policy concern, you know, using something which is really more of a public interest kind of mechanism for a commercial or a private purpose. It also wasn't really clear to us that what holders of options generally want is the ability to enforce that option just against any person that happens to own the land, because the obligation in the option to transfer the land is probably supplemented by various other obligations on the part of the landowner. And really what the option holder wants is for the landowner just to do what they said they were going to do under the contract, rather than necessarily being able to force some buyer one or two transactions down the line then to sell to the option holder. So something that was a kind of free-floating right to enforce against any person seemed less attractive than something that forced the original contracting party to stick to the terms that they agreed in the contract. So from that perspective, the conditional advance notice scheme seemed like a better fit. So on both those practical and policy grounds, we didn't think that was such a great approach. And we also looked at this question of a self-inhibition, which is something that actually Professor Halliday looked at way back prior to the introduction of the 1970 Act. So the idea here is, rather than a creditor inhibiting me, I could just grant an inhibition against a piece of property that I own that says I, you know, do not have capacity. I'm not allowed to transfer this bit of property to anybody apart from the person that I've agreed an option with. Again, it just seemed like a more complicated way of doing something that could be done more simply using this conditional advance notice scheme. So that was why we didn't take it any further. But as I say, we do outline those potential alternatives in the discussion paper, and we can look into any of those further if the view amongst consultees is that that is something we should be doing. So those are also set out there in the paper for you. Okay, so that's us at the end of the non-monetary security stuff. If you're a banking person who's just been waiting with bated breath for the sub-security stuff, then, you know, it's your moment. It's your time to shine. Okay, so as I said at the start, when I'm talking about sub-securities in this context, what I'm talking about is a standard security held in another standard security. So a secondary standard security or a piggyback standard security. Now, the problem with the problem with this arrangement at the moment, so first of all, when we started looking at this in the first discussion paper, we investigated where these sort of arrangements were being put in place in practice. And certainly the most common example is in kind of securitization or debt warehousing, these kind of like complex financial structures. But what I wanted to do is just try and bring this down to the absolute basics of what is happening in a sub-security arrangement to explain to you why I think it doesn't make any sense to take a standard security over a standard security. So I'm just going to try and break it down to the real basics of what's happening in a sub-security arrangement first, before getting into the questions that we're asking about what the reforms to the law should look like in future. Okay, so in a sub-security arrangement, what you've got, first of all, is B, person B, holds a claim to repayment against A, and also a standard security in his house in respect of that claim to repayment. So let's say that B in this context is a high street bank, A is a homeowner debtor who has borrowed money from the bank so they can buy their house. So the bank's got a claim to repayment from person A in respect of their home loan, and then the bank also has a standard security in his house. Okay, so far so straightforward. That's the first part of it. We sometimes refer to that as the primary claim. Then after that, let's say that B, the high street bank, borrows money from C. Let's say C's an investment bank. So B borrows money from C, and B offers his secured claim against A as collateral for that loan, that secondary loan. So B is your high street bank. They're borrowing money from C, which is the investment bank. In security for that second loan from the investment bank, B offers his claim against this homeowner. That's the collateral that's being offered. What happens in the arrangement is that C will take two rights in security over B's secure claim against A. So C will take an assignation in security of B's claim against A, the claim to repayment against A. So C will take an assignation in security of B's claim against A. And then C will also take a standard security over B's standard security, which is held in A's house. So that's the second part of the security package, if you like, is C taking a standard security over B's standard security, which is held in A's house. All right, so that's the essence of what is happening in a sub-security arrangement. Now, the reason why I don't think this makes any sense to take a standard security over a standard security is because ultimately the purpose of a right in security, any right in security, the purpose of a right in security is to allow the security holder to realise funds from the security subjects if the obligation is not voluntarily performed, you know, if the debt is not voluntarily paid. The purpose of the security is that if you're the security holder, you can sell those security subjects, you can sell that security property, or you can lease it out, or you can generate an income from it in some way. That's the point of taking your security. It needs to be an asset from which you can realise funds. Now, that makes sense if you're taking as a security item a claim to repayment. You know, if you're taking an assignation in security of a claim to repayment, that makes sense, right? Because you can generate funds from a claim to repayment. You can either just wait for the installment repayments to come in month by month, and then you're getting money that way, or more likely you can sell the claim to repayment. You know, there's a market for that. People will buy that. So you can sell the claim to repayment and you get your money that way. So the claim to repayment is an asset with a financial value that can be realised. The problem with the standard security is, how are you going to realise funds from the standard security independent of the claim it secures? Right, so the claim it secures has a value, but the standard security itself, independent of the claim it secures, it's not really worth anything. Like, it will enhance the value of the claim it secures, but in itself, who's going to buy that? Like, there's no, why would you want a standard security if you don't have the underlying claim? There's no way that you can make money from it. There's no market for it. You can't use it to generate rent or royalties or license it in some way. Like, a standard security does not have any independent financial value. And that's because the whole purpose of a right in security is that it is accessory to the underlying claim. The underlying claim has value, the standard security enhances that value, it's only accessory, it's like attached to the underlying claim. Well, attached is a bad word to use there because it has technical meaning and other aspects of the law of rights and security, but the standard security is of value when it's with the claim. It isn't of any value when it's separated to the claim. So that's why the idea of taking a standard security over a standard security just doesn't really make any sense, because the standard security doesn't have an independent financial value. And that central difficulty, the fact that the standard security doesn't have any central financial value or independent financial value, is why it's so impossible to find an enforcement scheme for standard securities over standard securities that work. So like you can't sell it, like normally you would sell security property, but you can't sell a standard security separated from the claim it secures because nobody would buy it. Some people suggested maybe you could, the standard security over a standard security holder could step into the shoes of the primary security holder, but that also doesn't really work, because normally if you have a process like that, the value of the asset that is being acquired will be offset against the debt. So if the secondary standard security holder steps into the shoes of the primary security holder, what value are you offsetting against their debt? Like there's no value that you can assess. It just doesn't really make any sense. So I just think using a standard security as a security property or as security subjects in its own right is just, it's sort of incoherent. So for that reason, then what we are consulting on is the idea that in future legislation, it should no longer be possible to take a standard security over a standard security. We suggest that should no longer be competent, and we look for views on that. Then the question becomes, well, then do you need alternative provision for taking security over a standard security? Like, do we need some other way of doing that? Now, if you do need to do it, the obvious way to do it is to allow for a standard security to be assigned in security. It's not possible to assign in security a standard security at the moment because sections 9.3 and 9.4 of the 1970 Act prevent that from happening. So just stay at the start, future legislation will not have any equivalent to those subsections. There won't be anything in future legislation that expressly prohibits assigning in security a standard security. That won't be a problem anymore. That barrier will be removed. But I would just ask whether it actually makes any sense to characterize an assignation of a standard security in that context as an assignation for the purposes of security. So let me explain what I mean by that. So under the law at present, if a claim to repayment is assigned, the assignee of that claim is entitled to acquire any related security. Okay, so if I have a claim to repayment against you and I assign it to a third party, that party is also entitled to acquire any security I hold in your property in respect of that claim. That is the case as a matter of common law at the moment. That will be put onto a statutory footing once the Movable Transactions Scotland Act is brought into force. So if a claim is assigned, the assignee of the claim is entitled to acquire any accessory security. That already is the law. And that is true whether that claim is being assigned outright or whether it is being assigned for the purposes of security. So my claim against you, if I assign it to somebody else, it doesn't matter whether I'm just outright assigning it to them or if I'm just signing it to them for the purposes of security. Either way, they're entitled to acquire any security right I hold in respect of that claim. Now, it doesn't make any sense then to say that if they acquire that security right from me, that is an assignation in security of that security right. Again, I don't know if that really makes any sense. Like when you think about assigning something in security, you know, when we say that something is being assigned in security or for the purposes of security, what we mean there is that the law will imply certain terms into that arrangement. Most obviously, it will imply in the term that the thing that has been assigned should be reconveyed once the debt has been paid off. But you don't need that to be implied into an assignation of a standard security, because the law already tells you that where a claim is assigned and reassigned, then an associated security, an accessory security has to go with it in one direction or the other. You know, you don't need to say the assignation of the standard security is in security, because the law will already imply in a right to reassignation of the standard security if the primary claim is reassigned. So saying that the standard security is being assigned for the purposes of security, I just don't think you need to say it. I don't think it really makes any sense to say it. Like, to me, maybe all we need to have in future law is just what we already have, which is you can assign claims in security. When a claim is assigned in security, the assignee has the right to acquire any accessory security. And then if the claim is assigned back, then on the reassignation, the original holder will be able to get a reassignation of the standard security too, as a matter of the general law. You don't need to say that that's in some way a security arrangement, because I don't think that it is. Anyway, that's where I stand on it. I don't think we necessarily need any provision for this in future legislation. But having said that, people have disagreed with me before now in discussing this project, and perhaps you disagree with me also, in which case I'll just reiterate, I've got no desire to prevent assignation and security of standard securities if people think we need that, and we will provide that if it's needed. I just would ask you to think about whether we actually need to provide that or not. So it would be great to get people's views on that. Okay, so that's the end of it. The consultation paper, the consultation on the discussion paper is open until the 29th of September. So still plenty of time. As I say, please don't feel the need to submit a lengthy, 10,000 word response. Just simple responses, yes and no answers is great. Partial answers are great. Lengthy responses are also extremely welcome, just to be clear. I'm not saying we don't want those, just don't feel like you have to do that. And we want to hear from as many people as possible, so please do get in touch.